The FBI came out today and said this Omar Mateen, they looked at it in 2013 and 2014. They decided that he was not involved in this suicide bomber, so he was not really on a watch list, even though they'd been watching him. They knew about it. They knew what was going on. But as of last week, he was not on a watch list. So what about the argument, people would say, he should not have been able to get his hands on a gun. He should not have been able to get his hands on an assault rifle. Well, why not? He wasn't on any kind of a watch list. Did we miss something? Am I missing something? Should he not have been able to go in and legally purchase a gun?
Yeah, I completely understand the search for an answer or for a fix to try to prevent something like this from happening in the future, and looking at why it happened and try to identify some flaw in the system, perhaps. The reality is that merely being on a list or being looked at or even being investigated by the state or federal authorities does not render someone incapable of purchasing a handgun. As a Second Amendment right, that right can only be taken away once someone is convicted of a crime or in certain other limited circumstances. But being suspected of being a criminal or being on a list is not enough to forfeit someone's Second Amendment right. Now, that being said, the fact that this gentleman had a license to purchase or carry a firearm does not give him the right to go into a bar and carry an assault rifle into the bar. So having removed his license or preventing him from having the license to carry a gun would have done nothing to solve the situation, because he was already violating the law by bringing the assault weapon into the bar.
Let's talk about